Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by Serenade e-Immigration. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And while I recently had the opportunity to talk to the folks at Serenade about their case management system, e-Immigration, they've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. My goodness, everyone. Only one case this week, and it seems like everything happened in immigration news this week. That is until all of the things inevitably happen next week, in what is already turning out to be quite the 2025. So I'm going to give all of that news and all the happenings its own segment of this show. Again, only one case. Before we get there, congratulations to my Ayla South Florida colleagues on what appears to have been a very successful and very fun annual conference. Loved all the photos on social media. Savor the joy. Here comes the chaos. Let's run down the immigration actions of this administration just this week. First, by my count, on Valentine's Day no less, the administration fired 14 immigration judges and 6 assistant chief immigration judges for no other reason, it would appear, other than the fact that some of them were on their probationary period, and all of them, I think, assumed office under the Biden administration. Again, I think. It's absurd and highly offensive to me as a former EOIR employee. The firings include our local ACIJ here in San Diego, and in my experience and by reputation, she is a wonderful and highly qualified person. Looks like the BIA is under attack too. In addition to firings, I'm seeing reports that the Trump administration is going to contract the BIA's numbers, make it smaller. Clever way to fire those who are not in their probationary period without cause and in otherwise violation of the law, right? Also quite the move, given the fact that it was the Trump administration the first time around that expanded the BIA and put in people that it thought it wanted to be there, which is another word for saying it packed the BIA. Bet you $100 that they expand it again in about a year with different individuals that they believe are more in line with, how should I put it, their views. If the reporting is true, and they truly are about to change up the numbers of the BIA to make it smaller to get rid of people they don't like, and if they then expand the board again and include people they do like, that would be a truly exceptional abuse of power, if you ask me. All the more so because the Democrat administrations are clearly not only not playing by the same rules, they're not even playing the same game. Don't get me wrong, I don't want them to. I don't want anyone playing this game. But these are the consequences of one side not abiding by long-standing norms. And just getting started here, really. Did you hear about that ICE trial attorney in Dallas who has apparently been running an overtly racist and white nationalist Twitter account for years? His Twitter handle is Glomar Responder, which I must admit might be the nerdiest handle I've ever seen. So what, you're neither confirming nor denying that you're not a racist? A FOIA pun? Really? Come on, man. Good luck to you, though. And if the reporting on this is not correct, I will retract what I said here in a future episode immediately, because this is very serious stuff. Also, Secretary of State Rubio has seen fit to designate as terrorist organizations lots of cartels in Mexico, MS-13, and other gangs in South and Central America. Don't get me wrong, they're all horrific organizations. But the result of him doing so, as the Secretary, and certainly Stephen Miller, know, is that arguably all gang-based asylum claims, or most of them, risk a material support bar finding if the asylum seeker gave anything to these entities under duress. And any non-citizens who used a cartel in Mexico to enter the U.S. also risk a material support bar, no matter what they're applying for. Because the cartels control every inch of the Mexico-U.S. border, so I'm told, and BIA case law has developed in the cruelest way possible so as to preclude any duress or de minimis exception to the material support bars. Oh, and USCIS is boasting on social media how they're working with ICE to remove non-citizens. And DHS Secretary Noem rescinded one of the Haiti TPS designations. We're suing. ACLU just sued on the Venezuelan rescission, if you didn't see it. Welcome to the jungle! Want to get a bit boring? Well, this week, the Ninth Circuit amended its Episode 238 Aleman-Beloso decision. It's still a remand, and it's still quite good for non-citizens, but it's amended. And the Ninth Circuit then amended its Magana decision, Episode 244. Just so you know that I'm not missing these ones, guys. Just so you know. Finally, as I step off the soapbox, I'd be remiss not to reiterate how my heart is with all of the terminated federal employees, immigration or otherwise. People who have dedicated everything and sometimes found their dream jobs with U.S. aid or the national parks, or hell, even the IRS and any number of positions and agencies. These are highly qualified people who love their country, who've served their country, whose lives have now been upended by a billionaire, and whose work was some of the most important work there is. Like the most important and valuable. To all these terminated employees and federal employees who are nervous, who are still there, you have allies, and I'm one of them. I'm so sorry you're going through this. Thank you for your service. So, here's your one case this week. After these short messages. Welcome back to the fold, Staffy. We love to have you. Are you fighting like a maniac, completely overwhelmed by the chaos of the new administration? Immigration policies are shifting fast, the pressure is piling up, and clients are desperate for help. You're working around the clock, but there's only one of you. Well, Staffy's got your back. Staffy's bilingual virtual paralegals and administrative assistants handle USCIS forms, client intake, evidence gathering, and scheduling, so you're not drowning in paperwork while trying to fight for your clients at the same time. Stop running on empty. Staffy gets you a trained, ready-to-go team fast with HR-backed support, onboarding, and continuous training. You don't have time to do it all alone, and you don't have to. Schedule a consultation at staffy.cc, that's stafi.cc, and claim $500 off your first month. Elevate your advocacy and storytelling skills at the annual Immigration Court Trial College in Kansas City. Get ready for a transformative experience at the annual Immigration Court Trial Advocacy College, now hosted by the Pen and Sword, formerly the clinic at Sharma Crawford Attorneys at Law. That's friends of the pod and friends of the Kevin, Rekha and Michael Sharma Crawford, excellent immigration attorneys. The The college convenes from April 24th to 26th and will focus on detentions, bonds, and release for 3 action-packed days of hands-on practical training and expert insights. This is not your average Talking Heads program. This is real cases, real witnesses, and real courtrooms designed to give you a real edge in your immigration practice. Put another way, this isn't just another training. It's an opportunity to transform your practice and fight for justice in a way that matters. Sharpen your skills, amplify your voice, defend immigrant rights like never before. Don't miss out, because space is limited. Check out all of the links to Rekha and Michael Sharma Crawford, their firm, and the Pen and Sword in the show notes. And if you want to get a bit of a discount for the Trial Advocacy College, click on the link in the show notes or use promo code IMREVIEW2025. That's IMMREVIEW2025. Keep up and join the good fight. Our only case is El Manyary v. Bondi, published by the 8th Circuit on February 21st, 2025. This case is about in absentia motions to reopen. Mr. El Manyary is from Morocco and entered on a K-1 fiancé visa in 2006. 90-day fiancé, anyone? Yes, that. Our claim to fame in immigration. And he got married in time, as he was supposed to. And he applied to adjust to LPR status, as permitted. But Mr. El Manyary and his wife didn't appear for their USCIS adjustment interview, and so USCIS denied the adjustment of status application. USCIS then issued Mr. El Manyary a notice to appear in immigration court. He was, after all, now in the United States without valid authorization. Turns out Mr. El Manyary was getting divorced. He received the NTA and the follow-up hearing notice because he hired a lawyer who obtained a continuance of the first date, so we know that he received these things. But Mr. El Manyary didn't appear at the continued hearing, and he was ordered removed in absentia. Seems like that happened in Minnesota. He had been living in Florida the whole time, it seems, and he got remarried, and 7 years later moved to reopen his removal order. That removal order, like I said, had been issued in Minnesota, and Mr. El Manyary alleged that he had not been able to travel there from Florida in 2007. An immigration judge denied the motion. The motion clearly wasn't based on a lack of notice of the hearing, and if it was ostensibly premised on exceptional circumstances that prevented Mr. El Manyary from attending the hearing, well, it was untimely by like 7 years. Those motions must be filed within 180 days of the in absentia removal order. Side note, if I ever get these days from statute or regulation wrong, don't rely on me, and don't sue me. This is not legal advice. Look at the statute and the regs. Anyway, in his papers, Mr. El Manyary also asked the IJ to reopen proceedings sua sponte, asserting how bad removal to Morocco would now be for him and his wife, particularly as her wife had a medical condition. But the immigration judge denied that too, that is, sua sponte reopening. Remaining in the United States, Mr. El Manyary tried again 5 years later. By this point, the Supreme Court had issued Pereira and Chavez, and those decisions were all the rage. And Mr. El Manyary alleged that notwithstanding receiving the NTA and the notice of hearing, he didn't receive proper notice of his hearing because the NTA was deficient. It lacked the date, time, or location of his first hearing in violation of INA Section 239A. And as I've kind of talked to death on this podcast, while factually this all may seem a bit silly, it is the correct reading of the in absentia reopening statute. It really is. In absentia removal orders that began with deficient NTAs should have been reopened under that statute. Except Justice Alito and 4 justices disagreed in Campos-Chavez last term, episode 216. If you'd like to hear my thoughts again, up to you. Justice Gorsuch and his companions in the dissent were as flummoxed as I. So Campos-Chavez wrecks that argument, right? Even if it hadn't been issued by the time the IJ and the BIA denied the argument below, it would appear. Mr. El Manyary also made another argument, it seems. More in line with Pereira and Chavez, if the notice to appear was deficient, his continuous physical presence in the U.S. never stopped, even with a removal order, meaning that now he was eligible for non-LPR cancellation or removal under INA Section 240A-B. He's got the 10 years and a qualifying relative, his wife. That argument would seem to have legs even with the BIA, matter of Chen, episode 142. Nevertheless, the second motion to reopen was denied. Because that motion still largely travels under the sua sponte provisions, and to get sua sponte reopening under BIA precedent, you have to present exceptional circumstances. The BIA didn't see them. As to the Eighth Circuit, it affirmed all denials of that second motion to reopen. Seems that Mr. Manyary actually had an argument about the insufficient notice, notwithstanding Campos-Chavez, albeit not a winning one. He argued that the hearing notice did not and could not cure the deficient notice to appear, because it was written in English rather than in Mr. Manyary's native Arabic. But, quote, the statute does not require notice in any language other than English, end quote. Also, Mr. Manyary knew about the hearing, and his attorney spoke English and even obtained a continuance for him. Quote, his counsel's receipt and understanding of the notice can be imputed to Mr. Manyary, end quote. Moving on, it also appears that Mr. Manyary did not in fact put all his eggs in the sua sponte reopening basket after Campos-Chavez, after all. He did argue that the BIA should have equitably told the time permitted to reopen under the statute, given the change in law that is Pereira and Chavez that made him potentially eligible for cancellation of removal all these years later. I think that was the argument. But the Eighth Circuit held that Campos-Chavez precludes this argument, reading that decision as having held that, quote, receipt of a proper paragraph 2 notice bars challenges based on defective notice, end quote. Paragraph 2 notice being a notice of hearing. And if the argument and its rejection here is still about a lack of notice type motion to reopen, I get it. Campos-Chavez precludes it. The notice of hearing cures it. But if the Eighth Circuit is saying that Campos-Chavez held that notices of hearing implicate the stop time rule even if an NTA is deficient, that's not right at all. That's squarely Pereira and Chavez. So maybe I'm misunderstanding something. Because also, if instead what Mr. Manyary is trying to equitably toll is 180 days to move to reopen an in absentia removal order based on his inability to travel to Minnesota, I fail to see the relevance of Pereira and Chavez or the stop time rule issue at all. Suffice it to say then, I'm flummoxed again. Turning, though, to the sua sponte motion to reopen request, yes, the BIA could have done it to permit Mr. Manyary an opportunity to apply for cancellation of removal. But it doesn't have to, and more importantly here, the Eighth Circuit held, as is so often the case, that it lacks jurisdiction to review the BIA's denial of a sua sponte motion to reopen. It's all just too dang discretionary. Good counsel, though, remember, if you haven't caught on already, quote, Mr. Manyary asserts his case is different because it involves specific legal questions and claims the BIA did not clearly consider when it rejected his arguments, violating his due process rights. However, an argument that the BIA overlooked certain relevant circumstances cloaks an abuse of discretion argument in constitutional garb, end quote. Fair enough. And I guess pre-colonial pastels. To the Eighth Circuit, it doesn't matter that the hardship standard for non-LPR cancellation of removal might be a mixed question of law and fact, thereby permitting review on the merits of a hardship denial. When it's all part of a sua sponte reopening request, the BIA is simply considering all of it, including hardship, as factors in its just too dang discretionary analysis. Meaning, Mr. Manyary lost a complicated case and will remain ordered removed. And that is Manyary v. Bondi. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And you know, we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.